Washington, D.C. Today we're going to be explaining pleading guilty in D.C. Superior Court. And this is a PowerPoint presentation that goes into pleading guilty in D.C. Superior Court and what you would be required to do. We're essentially going to go over the form. Let's start. So let's go ahead and start. This is the actual form that you will be signing in D.C. Superior Court. This is called a plea agreement and waiver of trial form. Now, whether it's a no permit charge or a murder trial, a murder charge, this is the exact form that everyone is going to sign. This is the form that you have to review with your lawyer and make sure that you fully understand it. So we're going to break this form down. Obviously, the first thing is that your name is going to obviously go to the top of the form, and understanding that you're going to put your name there. The next part of it is that you're going to talk to your attorney and talk to us, whoever your lawyer is, and you're going to make sure that you want to know who the entity that's prosecuting you is. Now, there's two prosecuting entities in the District of Columbia. That's either the U.S. Attorney's Office for D.C. or the District of Columbia, and also referred to Office of Attorney General. That's the D.C. prosecutor. Now, that would usually be circled or highlighted of which one is prosecuting the case. The next part is your case number. That's the case that's assigned to the case that to keep track of the matter. And then finally, the other part of the form, which you can see, is the plea agreement. That's usually written in by your attorney. Sometimes it's typed in, but regardless, it will be in on that form. The next part. So we're going to break down the form a little bit and first go through the plea agreement. Now, this is the actual agreement that obviously you should have reviewed with your attorney or reviewed with us at this point, and you're trying to make a decision of whether you're going to be entering a plea. And the reason why we start here is because if you can't get past this part, then you don't need to watch the rest of this PowerPoint presentation, because you're admitting in this part that you committed a crime. So that plea agreement is basically saying if defendant pleads guilty to blank, the government will do such and such. So you're admitting that you did the crime right here. Now, the prosecutor is going to read the facts of the case in open court, and you're going to have to agree to it. So the plea agreement is read in open court, and then the prosecutor reads the facts of what they say that you did, and you have to accept that. If you do not accept that, which is, you should know this before you proceed on with the plea agreement, if you do not accept that, then there's no reason to go through the rest of the form. If you do accept that, then let's continue on. The first thing is that you have to understand that you're giving up a constitutional right. So you do not have to plead guilty. It's at the beginning of the form. If you look at the form, you'll see that this says you are not required to plead guilty. If you do plead guilty, you'll be giving up important rights, some of which are stated in the form. So the most important thing is to remember is that you do not have to plead guilty. It's said over and over and over again. They're trying to let you know that this is not a forced requirement. You do not have to do this. You're giving up your constitutional rights, by pleading guilty. So you're waiving some rights if you plead guilty and you do not have your trial. So the first thing, and it's the first paragraph in this form, it says you're giving up a right to have a trial by the court or jury. So whether you have a right to a trial by court or jury, that's obviously a factor that you have to go through with your attorney or with us. You're basically, that decision should be made already, whether you're entitled to a trial by court or by jury. Low-end offenses, misdemeanors generally do not get a jury trial. Felonies, anything greater than a year, usually gets a jury trial. So that just a brief overview of whether you get that right to a trial or jury by the court. So when it says by the court, basically that means that the judge will decide the facts of the case. If it's by a jury, that means that 12 members of the community make the decision. And the next factor is, remember, you're presumed innocent. There's a cloak around you that basically says you did not do the crime. You presumed it. You're presumed to not have done the crime. The prosecutor is required to prove in open court. It means that they have to call witnesses. They have to put everything on. If you say, I want my trial, the prosecutor is required to prove that in open court. And they must prove it beyond a reasonable doubt. Now, some people say, what is reasonable doubt? Well, we have this diagram that sometimes we're able to use in court in a jury trial. Some judges allow it, some do not. But you can kind of see where the factors go, and these are kind of the factors, and you say, no, that's not reasonable doubt. These are the factors. These are considered perhaps suspected, possibly guilty, probably guilty, guilty likely. That's not reasonable doubt. So at the top, you can see reasonable doubt. So remember, they have to prove that in open court that you committed the crime beyond a reasonable doubt. At trial, your lawyer would be there to represent you. So the lawyer, there's us or some other lawyer, they would be there to represent you. And that lawyer would cross-examine the witnesses. He can make objections. If you've ever seen TV shows, you see objection. The judge makes a decision of whether the evidence comes in or doesn't come in, but all that's given up by pleading guilty. The lawyer can make arguments for you. So during the end of the case, the lawyer makes what they call closing arguments. The lawyer could file motions to suppress. These are constitutional issues. Maybe the police officer did something wrong, and the lawyer could file a motion to suppress the evidence. But remember, once this form is signed, there won't be that right to have motions to suppress filed. The lawyer could subpoena witnesses to come to court. Somebody doesn't want to come, they can force that person to come and testify on your behalf. And you can testify if you wanted to. So you don't have to, you can participate in your trial and you can get on the stand. The lawyer cannot even tell you whether you testify. If you want to get on that stand and testify, you can. He can give you advice, but you're the one who makes that decision. And obviously you cannot be forced to testify. So the prosecutor couldn't call you as a witness. You can sit silent through the entire trial and you wouldn't have to say anything. And again, last but not least, remember, there would be no conviction unless they prove your guilt beyond a reasonable doubt. So, second thing on the form, this says you give your right to the Court of Appeals. Now, the Court of Appeals, it's a court right across the street, 9 judges sitting over in the Court of Appeals. Your case would be appealed from the trial judge to appellate judge. Usually your case is heard by a 3-judge panel, and they make a decision of whether the trial judge messed something up during your trial. If they messed up during your trial, they could send it back down to him to correct the mistake. But if you're convicted, if you sign this form, you will not have that right to appeal. But if you went to trial and you were convicted, you would have a right to an appeal. You could take your case across the street, and that means that a lawyer could be appointed. If you couldn't afford a lawyer could be appointed to handle the appeal process. Now, recently, they've added this part to the form, which basically says that you're waiving your right to an appeal on any basis, even if the statute changes or later deemed to be unconstitutional. It's a little bit of controversy because there was a gentleman in the news lately, a guy named Flynn, and he was able to take back his plea, or they would dismiss the case even though he pled guilty on this, using a form like this. So even if the admitted conduct does not fall within the scope of the statute, it doesn't matter. You've signed this plea, you admitted in open court, they will not allow you to take back your plea. So it's permanent. The next thing on the form is citizenship, meaning that if you plead guilty to some charges and you're not a U.S. citizen, you can be deported. That means, obviously, you know what that means. You could be deported. If you plead guilty to certain charges and you are not a United States citizen, you can be deported. So it's imperative that you talk to your attorney, go over the facts of the case, make sure that you understand that by pleading guilty to some charges, you could have serious consequences, not just jail, but it could cause your deportation. And the last thing on this form is your signature. Now, your signature on this form means that you wish to plead guilty and give up your right to a trial and your right to appeal. If the court accepts your guilty plea, you will be convicted, and the only matter left in this case will be for the court to sentence you. No person can guarantee what the sentence will be. We're not going into the sentencing in this PowerPoint presentation. That's a different presentation. But recognizing that once you sign this form, it's not over, because you still have to admit all of this in open court. And you still have to go in and you have to admit under oath that you committed the crime. And the last part of this form obviously says, I reviewed this form with my lawyer and I've decided to plead guilty in the case. I understand the constitutional rights that I'm waiving and I'm giving up my right to appeal. So I hope this helps to understand what the plea form is and what you're admitting guilt to. If you have any questions, feel free to call us. Thanks for watching. Thank you. Bye.